Katy, what would you say are the key issues which arise in the law on child abduction?
There are a number of key issues in child abduction, but one of the major issues, as you know, is the issue of habitual residence. There's a tendency for people to think that child abduction is a very niche area, and it can certainly be a niche area for practitioners. But as you know, habitual residence, which is an issue that has been litigated in child abduction over no less than about 6 Supreme Court cases recently, is one of the major issues in child abduction that has actually transcended all areas of family law. It is a relevant aspect in all areas of children law, for example, in public law proceedings involving children, private law proceedings, and it has become the issue that the court must satisfy itself of in order to permit proceedings to be pursued in this jurisdiction.
And what, if anything, are the recent emerging issues in the courts in child abduction at the moment?
Well, there are a few emerging issues, but at the moment, one of the most pressing one is obviously related to Brexit. And as you know, we've got Brussels to revise the Council regulation, which is currently applicable in almost all cases in child abduction, and provides the basis for jurisdiction for the court in matters relating to parental responsibility. And over the years, the European law has certainly been linked to an extent into English law, so that now, with Brexit, there's quite a level of unravelling that will have to be done by the courts. And after the 31st of December of 2020, the court will have to grapple with issues as basic, such as jurisdiction, for example, and there will have to be a fallback on the 1996 Hague Convention. So at the moment, that is an issue which clearly is going to give rise to a lot of litigation post 31st of December this year.
And I've noticed from my experience that there is a move in relation to the court's approach to protective measures. Is that something that you'd agree with?
Oh, absolutely. As you know, since the Supreme Court case in Re in 2011, the court had announced a slight shift in emphasis in the way that we approach protective measures in child abduction cases. And in particular, what the Supreme Court was saying is that we need to have a closer scrutiny of the actual efficacy of the protective measures that are put forward in child abduction cases. But for some reason, that message was not well heeded in the subsequent years until around 2016, when the case of GP went to the Court of Appeal, and now there is a lot more emphasis on the court actually scrutinising protective measures and their efficacy in the country where the child is going to be returned. Traditionally, we have had a tendency of simply accepting undertakings by way of protecting measures. So, for example, an applicant, for example, a left-behind parent could offer undertakings in return for a child to be returned in a case where there is an Article 13b defence being raised, that is a defence based on the grave risk of harm to the child. And as I say, traditionally the court has been well-minded to accept undertakings in the same manner as we would do in domestic proceedings, but that's no longer the case. There is now several Court of Appeal cases which say that the court must look very closely at whether these undertakings are going to be enforceable in the other country. And certainly we now know, and we have known for a very, very long time, although not much attention has been paid to it, that non-common law-based jurisdictions do not recognise undertakings in the same manner as the English court does. And that is certainly an issue now which as a result of the numerous authorities that are now coming out of the Court of Appeal, all cases have to address at the very outset. So an applicant and a respondent will be well advised now to set out from the very start of proceedings whether, for example, if undertakings were offered as protective measures, they would be enforceable in the country where the child would be returned, and if they're not enforceable, what the law of that state, of the other state, says in relation to what measures might be taken in order to effectively protect a child upon return.
Finally, we're conducting this conversation remotely. How have the courts been affected by the pandemic? Have hearings been going ahead?
They have been going ahead. As you know, child abduction cases always entail an element of urgency, and most judges have been doing their best, striving really to make sure that abduction cases are given priority and they are heard, because more often than not, in an abduction case, you find that when a child is brought into this country, particularly, that there may be a level of severance of their relationship with a left behind parent. So the court has been doing its best to ensure that there is no backlog insofar as abduction cases are concerned. And interestingly, we've been using all manner of platforms in order to ensure that cases are conducted fairly. So I have done a number of final hearings in child abduction cases using all the different remote platforms that are out there, including conducting cross-examination, and in no case that I have done so far has there been any suggestion that any unfairness has resulted because of the manner in which hearings are being conducted remotely at the moment. So I would say my experience has in fact been very good insofar as abduction cases are concerned, especially as the High Court practice is concerned, and all the work that has been happening during lockdown, I haven't seen any reduction in the level of cases being heard at all.